Folks, people are just starting to join us, so I will start once a few more have joined us. Just a few more seconds. Then we'll start. Okay, let's get going. I see some familiar names. Welcome. Thanks for joining me for the third of my 10-part series and for the feedback that I've received from many of you. Just before I forget, if you do want to reach out to me, please do so directly, and I'll just put my contact information up here. Those of you who are responding to the event invitation you get and responding to it, it goes directly to our marketing department and it takes a while to find its way to me. So please do reach out to me with feedback or questions or comments and use my Lerners email address. So as in the previous sessions, I'll talk for about 45 minutes and then I'll leave about 15 minutes for Q&A. I do have the Q&A box up, so if you have a question while I'm talking, I'll try to keep my eye on it and I'll answer it, but if I don't get to it, I will answer it at the end of the session. Just a reminder that this session has 1 hour of professionalism credit from the Law Society of Ontario. So just a little bit of an introduction to myself. I'm a partner at Lerners and an arbitrator at Arbitration Place. And I conceived of this series when I was doing counsel work and arbitration counsel work, as well as commercial litigation work. And I realized that there wasn't really a resource that I could use to get some practical information. My go-to resource is always Brian Casey's book on arbitration. And invariably, I find what I'm looking for there. But sometimes if I needed practical advice, it was a matter of calling somebody on the phone. And so this session, this series is designed to kind of create an opportunity for you to get more practical information than what you can find in texts. So today's session is called Bias and Challenging the Arbitrator Practical Strategies. And I've mentioned and emphasized the practical strategies part of it because we can all read the case law that talks about the test for bias and even the test for disclosure. But how does the analysis get done, and how do those tests get interpreted by the courts? And how should you conduct yourself in order to minimize the chances of challenges that will disrupt your arbitration? So I'm going to cover the ethical duties of arbitrators, again, the independence and impartiality requirement, tools available to analyze conflicts of interest, real or apparent, tips for challenging the arbitrator for bias, test and procedure, and finally, a few practical considerations when you're raising a challenge issue. So the duty of the arbitrator to be independent and impartial. Independence refers to the relationship between the arbitrator and parties, counsel, the dispute, perhaps other arbitrators, and may affect the interests of the arbitrator. For example, if an arbitrator has a financial interest somehow in the outcome of the arbitration. Impartiality refers to the actions essentially of the arbitrator and the requirement that the arbitrator provide a fair and equal process. And those two concepts are found in all the domestic legislation, the model law, and in the rules that are generally used by parties who resort to either ad hoc or institutional arbitrations, but apply rules. So that's where you find that language. What does it mean? There's a test for disclosure in the Ontario Arbitration Act, and I'm just using that as an example, which requires an arbitrator to disclose any circumstances of which the arbitrator is aware which may give rise to a reasonable apprehension of bias. The Ontario International Commercial Arbitration Act, which adopts the model law, uses slightly different language, which I'm going to call the international test. The arbitrator must disclose circumstances that likely give rise to justifiable doubts as to impartiality or independence. So we have the may language in the Ontario Arbitration Act, and we have the likely language in the international standard. And the interpretation of the international language has been assisted by a very important resource that I'm going to focus on in this presentation, and which I'll give you a link to at the end, called the IBA Guidelines on Conflicts of Interest in International Arbitration. And what it says about this justifiable doubts test is that the arbitrator is required to disclose facts or circumstances that may, in the eyes of the parties, give rise to doubts as to the arbitrator's impartiality or independence. So arguably, that requires a slightly higher level of disclosure on the part of the arbitrator, who must consider specifically the positions of the parties. What does that mean? It's not entirely clear, but it's possible to imagine a situation in which there are particular sensitivities that one or both of the parties may have in the arbitration, which may trigger perhaps a higher level of disclosure. And this is the test that the arbitrator should apply in deciding whether to either take on an arbitration, agree to an appointment, or continue to act, because this duty of disclosure is ongoing from the point in time when the arbitrator is appointed until the termination of the arbitrator's mandate. So that's the disclosure test. The challenge test, however, is higher and understandably is a lot more difficult to establish. The Ontario Act uses the same language, but excludes the words about which an arbitrator is aware. So the test is circumstances which may give rise to a reasonable apprehension of bias. And that language has been interpreted by the Supreme Court of Canada in a case called Committee for Justice and Liberty Canada National Energy Board, 1978-1, SCR 369. And that decision talks generally about the test for bias and a reasonable apprehension of bias, which the Supreme Court of Canada says must be a reasonable one, held by a reasonable and right-minded person. And the question to be asked is, what would an informed person viewing the matter realistically and practically and having thought the matter through conclude? So you can imagine that this is simply a matter of judgment and will be determined on a case-by-case basis. But there's an element of the reasonable person and the objective standard there. The BC Arbitration Act, the new 2020 Act, I want to highlight because it adds a slightly more difficult element of the test. It uses the international standard. So the BC Domestic Act uses the international test, which is circumstances existing that give rise to justifiable doubts as to the arbitrator's independence or arbitration or impartiality. But it adds an additional requirement. A challenge must establish that there is a real danger of bias. And I'm told by somebody who was involved in drafting that legislation that it was specifically inserted in order to discourage unmeritorious challenges. In other words, only serious challenges should be brought before the court or before the arbitrator or tribunal itself. The model law says that there's a challenge only if circumstances exist that may give rise to justifiable doubts as to the arbitrator's impartiality or independence. So if you look at the two standards, the disclosure standard and the challenge standard under both the domestic and the international arbitration, you'll find arbitration legislation. You'll see that the test for disclosure is slightly lower than the test for challenge. So that's the first important point that I want to make. The IBA Guidelines on Conflict of Interest, which, as I say, I'm going to refer to numerous times in this session, talk about what that challenge test really means. It's facts which, from the position of a reasonable third person, having knowledge of the relevant fact and circumstances, believes would give rise to justifiable doubts as to the arbitrator's independence or impartiality. So it's clear that there's no requirement that actual bias be established. It's an objective test, and the issue really is apparent bias. Doubts are considered to be justifiable under the IBA guidelines when a reasonable third party having knowledge of the relevant facts and circumstances would reach the conclusion that there's a likelihood that the arbitrator may be influenced by factors other than the merits of the case. So I'm just going to move forward because I've forgotten to advance my slides. Here we go. The IBA guidelines are being applied in the case law in both domestic and international cases where there's a challenge to the arbitrator. So notwithstanding the fact that there is different language used in the model law and the domestic legislation, it appears that the courts are interpreting that language to apply the same standard. The significance of all of that is that the disclosure obligations can arise at any time. They must apply where the arbitrator accepts an appointment and throughout the arbitration if issues arise. And that the test is no different whether the parties are at the beginning of the arbitration or they're in final submissions and the arbitrator learns of a disclosable issue. The obligation to disclose is the same. And so you can appreciate how important the due diligence requirement is to ensure that that just doesn't happen. The obligation ends essentially when there is the expiry of the period within which parties may seek either clarification or correction of an award. If there is a circumstances in which the court sends back a case to the arbitrator because it's set aside or on appeal, and the relief granted by the court is to set an issue or issues back to the arbitrator, it may be that new disclosures are required at that time. The disclosure purpose is obviously to give parties the opportunity to consent or not to appointing the arbitrator, notwithstanding circumstances which may give justifiable doubts. And the conflicts themselves range from waivable and non-waivable. So there are certain circumstances in which parties simply cannot waive the conflict of interest. And I think you see this if you compare that concept with what's in the Law Society Rules of Professional Conduct. You see there are similar situations in which waiving conflicts simply is not possible. In my experience, most conflicts are decided ultimately, assuming they're not ones that can't be waived, by the party's confidence in the specific arbitrator they've chosen. So if they know the arbitrator and have confidence in that arbitrator, it's very common that even issues which appear to be kind of on the line will be waived by the parties, because ultimately if they've chosen a decision maker in whom they've got confidence. The purpose, obviously, of these requirements is to maintain the integrity of the arbitration process while it's ongoing, and also to ensure that the award is enforceable and to protect the award. So the disclosure obligations invariably relate to the arbitrator's relationship to the parties, counsel, other arbitrators, and the dispute or the issue. And this is how the IBA guidelines are organized, often in those categories. So the sources that I've got on the screen now are obviously the rules of professional conduct, and those are for those arbitrators who are lawyers. Those rules of professional conduct that will bind you are those of your province of call. And as I've mentioned in the third point, the IBA guidelines of conflict of interest, which appear to be applied by courts in Canada in both domestic and international challenge decisions, but also the law of the seat of the arbitration is important and may include or add the obligation to the obligations that the arbitrator or counsel or parties already have. So if as an arbitrator you're not familiar with the law, you do need to educate yourself about the law of the seat to make sure that you're complying with that law. That will be the place where the award is enforced. And the difficulty may arise if there are inconsistencies among these various standards, which can arise in international obligations. And what I think you'll appreciate once we go through the IBA guidelines in detail, which I'm about to do momentarily, is that the gut test or your judgment sometimes won't be good enough because the calls can be quite close. So there's a tension, obviously, between parties' right to a fair hearing and the parties' right to choose a decision maker, which is the primary reason why parties choose arbitration. It's also important to appreciate that disclosure by the arbitrator is not a concession that there is a disqualifying conflict of interest or there is justification for a challenge to the arbitrator. And that's why the disclosure obligations are broader than the test for the challenge. But what it means is the general rule is, if you're in doubt, arbitrator, disclose. Is this a good thing? Certainly to protect the arbitration it is, but what it seems to result is an increasing number of challenges to the arbitrator, which are reflected both in the decisions that we hear about in the institutions because they report on such things and what we see in the courts. And those are sideshows sometimes that are very costly for the parties. And so the when in doubt disclose is certainly a principled position, but it can create problems for the parties when used. The information provided is used tactically by one of the parties. So when an arbitrator takes on a matter and there are issues that should be disclosed, there are standard disclosure forms that some of the institutions use, but if there isn't, the arbitrator should be sending to the parties a list of those circumstances which may give rise to justifiable doubts about their independence and impartiality, as well as a positive assertion that in the arbitrator's view, he or she does not believe that that affects their ability to act independently and impartially. And at that point, the clients will make a decision about whether they're prepared to proceed with the appointment, or if the arbitration is ongoing, to proceed with the arbitration. So in my firm, my colleagues and I who do arbitrations will then set up an actual confidentiality screen within our firms in order to maintain the confidentiality of the arbitration and to ensure or to minimize the conflicts that may come up in the course of an arbitration. So I'm now going to focus on the actual analysis of conflicts of interest and again on the IBA guidelines on conflicts of interest, which is, I think, the most helpful tool to be consulted in these circumstances. It provides the general principle that all arbitrators are impartial and independent, and that is a principle that you see consistently in the case law, that there is a presumption that the arbitrator is independent and impartial. This is a duty that extends not only to the arbitrator, but also to parties and their counsel. So they must alert the parties and the arbitrator if there are issues that may give rise to justifiable doubts. There is in the guidelines a 30-day period within which a party should object to any information provided as a result of disclosure. Otherwise, that party is deemed to have waived objection. There's obviously a very good practical purpose for that. And the IBA guidelines specifically state that this applies to med-arbs. And this can be important if, notwithstanding the parties having agreed to a process, an arbitrator learns something in the course of the mediation process, which gives rise to a concern about independence and impartiality. And there may be a requirement for either resignation or disclosure in that circumstance. So the IBA guidelines use what we call the traffic light system, red, orange, and green. And there is a duty to disclose when the circumstances fall within the red or the orange list, and no duty to disclose when they fall within the green list, because there is no appearance or actual conflict of interest. And there is both a waivable red list and a non-waivable red list. And the non-waivable red list applies in circumstances where there is an identity between the party and the arbitrator. So for example, and these circumstances sound unlikely, but they are referred to in the IBA guidelines. So for example, if the arbitrator is a director or an employee of one of the parties, or has a significant financial interest in one of the parties. The remaining circumstances in the waivable red list and in the orange list are circumstances that set out varying degrees of relationships between the arbitrator, counsel, the parties, and the issues in the arbitration. Just before I get there, the non-waivable red list, therefore, it contains circumstances in which there are justifiable doubts as to the independence and impartiality of the arbitrator. So the arbitrator must decline the appointment or resign. And the principle is that no party can be his or her own judge. There is some kind of identity between the arbitrator and the party. And this is usually a very, very close connection, which invariably is something that can be learned at the outset of the arbitration. So it would be very rare that this is a kind of relationship that would be discovered midway through the arbitration. The waivable red list lists circumstances in which their justifiable doubts could exist, but depends on the circumstances. So it's a case-by-case analysis. And parties can give their consent to these circumstances with full knowledge of them. And generally, they relate to the fact that an arbitrator has, for example, previously been consulted about a dispute, the dispute before him or her, has given an opinion, has a financial interest, or prior involvement. And again, to get the details, you should actually consult the guidelines themselves. There's 27 pages of fact circumstances and how they should be categorized. The orange list is considered to be a slightly lower, less close relationship. These are circumstances which may, in the eyes of the parties, give rise to doubts. So the arbitrator's previous services for a party or prior involvement in a case within the last 3 years, and includes 2 or more appointments for a party. And as soon as you start to get into time parameters and number of appointments, you of course get into uncertainties, which is why this can only be done on a case-by-case basis. So someone may say, well, what if it's 2.5 years and I've done 2 appointments for the same party? Does that put me within the orange list? And again, a matter of judgment. But the principle, if we go back to the principle of when in doubt disclose, the answer may be probably, although that fact situation alone may not be sufficient in order to make a determination. So the arbitrator and parties and counsel have to consider all of the circumstances to do the analysis. The orange list includes circumstances in which the arbitrators or the law firm is currently offering services for a party. There's a relationship between the party and the arbitrator. Either the firm is acting in an adverse capacity to a party, or there is friendship or enmity to a party, or even the arbitrator has publicly advocated a position on the specific case. Orange list circumstances parties can waive. The reality is that circumstances that fall within the red and orange list often give rise to a challenge. And it's one that may be waived early on, as I say early, based on the relationship the parties have with the arbitrator and their confidence in the arbitrator. But if they come up mid-arbitration, invariably they will lead to a challenge. The green list is circumstances that should never give rise to disqualification under the objective test, so there's no duty to disclose. And sometimes the biggest challenge in considering cases is whether the matter falls within the green list or the orange list. These are circumstances in which the arbitrator has previously expressed legal opinions on relevant issues, but not on the specific case, where there are contacts with another arbitrator or counsel that may be social or through professional organizations. Social media is a good example of that. Prior contact with the party during an arbitrator interview. So our last session was on permissible issues and approaches to an arbitrator. If those rules have been complied with and there has been previous contact between a party and an arbitrator, that is a green list circumstance which does not require disclosure. So the purpose of this tool obviously is to reduce or avoid meritless challenges. And it's arguable that the result is actually to increase challenges. But what we see both from reports from the institutions and in the case law is that challenges are rarely successful. The burden is very high. There are some complicating factors when counsel and arbitrators are considering disclosure issues. And I've listed some of them on the PowerPoint. First of all, the IBA guidelines are very detailed, but they're explicitly not exhaustive. So it's not so simple to say as, well, my situation doesn't fall within one of these circumstances, therefore I don't have an obligation to disclose. And some say they're actually too restrictive and impose too high a disclosure obligation. Nonetheless, they are very well accepted and appear to be the international standard, and they're what we've got. There's no clear dividing line between the various categories, which means it's common to have various circumstances which kind of have you wavering between whether this is a red list, waivable, orange list kind of circumstance. But other issues are complicating. Arbitrators in large firms, for example, the IBA guidelines identify arbitrators with their firms, and therefore the knowledge of the firm is the knowledge of the arbitrator, which can seem artificial, particularly for arbitrators in large firms, multi-office firms, perhaps international firms, where the knowledge of a partner in Paris is attributed to the knowledge of a person in Toronto. The IBA guidelines don't differentiate between that situation and a firm in which all of the partners practice regularly together in the same office. Corporate parties and affiliates. That's another challenge. How far in a large conglomerate does the due diligence have to go in order to determine there's a potential issue? The guidelines don't assist with that. What about facts not known to the arbitrator or the parties? And the answer to that is that they're required to undertake reasonable inquiries as part of the due diligence necessary in order to satisfy the requirement of disclosure. What does that mean? What are reasonable inquiries? That, of course, is not a defined term. Small markets and cultural differences. This is a huge one. If you are arbitrating in the city of Toronto, there are a relatively few number of potential arbitrator candidates who are well known by many and frequently used time and again. Does that create issues? The guidelines don't address that. And cultural differences. There are places in the world where there are greater concerns about challenges and independence and impartiality than there are in Canada, for example. Internationally speaking, Canadians are a lot more lenient in their view of disclosable conflicts. So if you're doing a lot of work in the international environment, you may need to look at these guidelines slightly differently. Third-party funders is another example. Third-party funders are considered to be essentially parties like insurers. So if the arbitrator has a relationship with or an investment in, for example, a third-party funder, that is a disclosable issue. And finally, relationships among arbitrators. Again, because the market's fairly small in some Canadian cities, you may find that arbitrators are sitting together on a regular basis, and they may be sitting sometimes as chair of a panel and sometimes not as chair. And there are dynamics associated with that, and the IBA guidelines don't really address that issue. Other issues that can complicate things are duties of confidentiality that an arbitrator, usually a lawyer, already has to existing clients, and how that can affect obligations of disclosure. And so there's a balance that needs to be done. And if the arbitrator has a duty of confidentiality to one party and cannot disclose a relationship, essentially that means that the arbitrator should decline the appointment. Greater issues arise if there's this duty and the arbitration has already started. Common grounds for challenge. These are the three big ones. I haven't included, the arbitrator's behavior, because it's rarely one that succeeds. There have been a few Canadian cases recently in which the courts have found that arguments that the arbitrator has been too involved in the process or arguably has entered the fray have not been successful. And so there are some arbitrators whose style is very interventionist, and they will ask questions of witnesses. They will manage the time in a very strict way. And all of those things, so long as the court has concluded that the process is fair, are invariably not valid grounds to challenge. And they've been tried numerous times and not succeeded. But here are some that are ones you need to keep your eye on. Multiple appointments by or against the same party. Again, that in some circumstances addressed in the IBA guidelines could give rise to an appearance of bias. Pre-existing relationship with a party or an affiliate. For example, an arbitrator having previously acted for a party, even if it was 25 years ago, or a party's partner or firm currently acts for a party and it doesn't get disclosed. Those sorts of things are sometimes justify a successful challenge. And issue bias. Previously expressed views by a party. So arbitrators need to be cautious about their marketing endeavors and articles in journals and that sort of thing, because those things could give rise to an argument of issue bias. What are the risks for a failure to make proper disclosure? The first is a challenge. A challenge in itself is costly, and it slows down the arbitration and it distracts from the merits issues. It could lead to a disqualification or a resignation. The arbitrator or the tribunal may decide to resign as a result, or may be disqualified by the institution or by a court. The award may be set aside on fairness grounds later on. If and this, we've seen this in the case that a party has learned after an award was issued, invariably it's the unsuccessful party, about an issue which it claims ought to have been disclosed. And then there may be award enforcement problems. But there are other issues, obviously, to the parties, there's a cost risk, and to the arbitrator, there's a reputational risk. So what's the test? So I've already outlined the Ontario Act, circumstances that may give rise to a reasonable apprehension of bias. And there are also specific tests in the rules that parties may apply. So I've cited the ADRIC rule. And what's interesting about the ADRIC rule is that the ADRIC rules generally are used primarily for domestic arbitrations, and yet the rule contains what I'm calling the international test, which is another reason why you're going to see this language commonly, regardless of whether you're doing a domestic or an international arbitration. And the procedure will depend on the law of the seat and the procedural rules the party has chosen. So the most important issue is, if you are considering raising a challenge, you must go to the relevant legislation of the seat and or the rules that the parties have agreed upon. So in Ontario, the challenge must be made quickly within 15 days of learning of the issue about which the party makes objection, after which there's a deemed waiver. And that application goes to the arbitrator. The decision of the arbitrator then starts a 10-day period within which the dissatisfied party may go to the court for a decision, and the court's decision is not subject to appeal. So you can see in the rule there's an attempt to have these matters dealt with fairly quickly, but as soon as matters go into court proceedings, we know how bogged down the courts are, and this will invariably slow down an arbitration. Under the ADRIC rules, notice has to go to both the arbitrator and ADRIC within 7 days. Under the VANIAC rules, to the arbitrator within 15 days. Under the ICC rules, to the ICC. And what's interesting about that is it doesn't go to the arbitrator. And both the parties and the arbitrator are entitled to make submissions, which means that the arbitrator will know about the challenge, but will not decide it. And to the ICDR with 15 days without notice to the arbitrator. So you see that there's a wide gamut of processes, and you can imagine the challenges that you face if your challenge must go to the arbitrator. That creates some awkwardness. It creates awkwardness both between the party and counsel and that arbitrator, but it also may create awkwardness within the tribunal if there's a challenge to just one member of the tribunal. Another practical issue is what happens to the arbitrator's fees if the arbitrator is removed or resigned. The Ontario Act says that if the arbitrator is removed for having acted fraudulently, it doesn't get any fees. But if it resigns or if it is removed for some other reason, this issue is often addressed in the institutional rules, but under the Ontario Act, there is provision, which a lot of people don't know about, for an assessment process of the arbitrator's account. And so there is recourse where an arbitrator has resigned or has been removed, but it requires yet another process. And then there's the question of whether the removal of the arbitrator terminates the arbitration. And that often is decided by the language of the arbitration agreement, and where a particular arbitrator is appointed under the arbitration agreement, it may be that the removal or termination of the arbitrator's mandate will terminate the arbitration itself. So that's a factor. Those are 3 factors that should be considered when you bring your challenge. The lesson is that arbitrators should be extremely cautious. You should read the IBA guidelines every time you're contacted. And I say to counsel, every time you are appointing an arbitrator, you should read the IBA guidelines. I've read them many times, and every time I read them, I see them differently in the context of the specific issue that I'm dealing with. And it's also a good idea, therefore, to make sure that there's early disclosure of the various witnesses that are going to be called by the parties, including experts, because there are situations, and there's a case in which the arbitrator had previously, in his role as counsel, retained an expert who was proposed to be an expert in the arbitration, and had to make disclosure of that in the middle of the arbitration. So if, as part of the case management procedural meeting process, you provide for very early disclosure of those issues, you minimize the chances that there will be something like that will come up that will put the arbitration off its wheels because of a potential disclosure issue. And another kind of common sense consideration is no ex parte communications between members of the tribunal and counsel or parties. And it seems obvious to say that, but there are circumstances where decisions have been rendered where that has occurred. And it can happen very easily when there are informal coffee discussions during lunch over the water cooler stuff in the middle of a hearing. So it's absolutely critical that parties, counsel, and arbitrators be vigilant that you maintain that separation so that there's not an appearance that there have been ex parte communications, which later could then give rise to a challenge. So I've now got to the end of my formal presentation. I don't see any questions and none in the Q&A panel. So please feel free to add them. I'll stay on for a few minutes, but I just want to give you a plug for my next session in January, which is about the first procedural meeting, tips to prepare and to get the most out of it. It will be on January the 12th, 2023, which seems like it's around the corner already. I'm going to cover opportunities for a just, speedy, and cost-effective determination of the dispute without sacrificing due process. There are a number of cases in the Ontario courts in the last few years in which parties have agreed to reduce either process or costs, like not ordering a transcript or not requiring the arbitrator to give reasons. And then one party regrets it because usually the loser, because the party doesn't like the outcome and then regrets having shortcutted the process. So it's important at the very beginning that parties consider what rights they want to preserve, what flexibility they're prepared to accept in the process in order to ensure that everybody's rights are preserved, but the matter proceeds most efficiently and cost and expeditiously. So that's one of the topics that I'll cover at the next section. Taking advantage of case management. What do you want to advocate for your client for in front of this person who is going to be the final decision maker on the merits, but also the person that's going to navigate and case manage the case throughout? And customizing the process for the dispute. You hear about that a lot, but what does it mean in practice? What does it mean making sure that you use the parts of a typical dispute resolution process that really get to the result in a just way in your case, and parts that aren't necessary to get there in your case, but might be necessary in another case? As always, at the end of this session, we'll be sending you a recording with the resources that I've talked about, and you will get a link to the IBA guidelines. Thanks very much for tuning in. I see somebody has given me a chat, has sent a chat. If you could put that in the Q&A, that would be better for me. I've got too many windows open. So my partner, instead of using the Q&A, has sent me an email. So this is from Earl Cherniak. One thing you might mention is that the losing party does not like it, especially in international arbitrations. Losing corporate parties often do a much deeper dive into an arbitrator panel than was done at the outset. Another reason to err on the side of disclosure at the outset. I think that's a great point, because it's going to be the loser who is looking for reasons to challenge the award. And in a domestic context, in many cases, you're limited to a challenge on a question of law, and counsel go through contortions to try to create grounds that are considered to be questions of law, often unsuccessfully. And in the international context, the set-aside challenge grounds are procedural fairness type grounds, not merits grounds. So one of the issues that the losing party will invariably look at is whether the arbitrator ought to have made disclosure or was in some way biased or not partial and independent. So I think Earl's advice about erring on the side of disclosure is critical, because because it essentially protects the award, which is your job. You have been hired to make sure that the parties at the end of the day have an award that they understand and that is enforceable. We've got a question. Addressing the potential conflict with experts. Practically, how do you address it if counsel haven't yet decided who to retain and aren't keen to give the other side any insight as to who they might retain? That is an excellent question, and one that you hear a lot from counsel who are thinking in the litigation mindset. If you totally embrace the idea that arbitration provides a different process and that it's a more expeditious process, and that in many cases, there's a lot more upfront presentation of your case. For example, in the way of upfront witness statements, then you appreciate that those kinds of concerns don't arise in the same way because parties are preparing all aspects of their case much early on, and they're giving consideration to retaining their expert at the very beginning and not waiting, for example, until after examinations for discovery, because there may not be examinations for discovery and will likely not be examinations for discovery in the arbitration. And so you've got to have a different mindset and prepare early. And there is an interest in both sides in actually doing that. So you may very well have concerns about, for example, the liability issues in your case, and you may not want to have an expert immediately until you know what that expert is going to say. But it's also in your client's interest to make sure that your expert doesn't create a potential conflict issue, which then sets the arbitration off the rails, or after you've already retained and paid the expert, disqualifies the expert. Hope that answers your question. Okay, that is the last question. So I will sign off now. We are a few minutes early. And Jim, I think I got your question. I told you had a hand up and I can't see it because of the format, but I think I answered your question. Okay, have a great day all, and I hope to see you at my next session next month after we've all had some rest. Have a great day. Bye.